right, this is the family law attorney docket A. This is generally Judge Evans' docket. I am covering for him today, Judge Haan. And so I know there are some presentations on here that obviously, if you don't have agreed orders, then I'm not able to sign off on those orders. But first, let me ask, are there any agreed continuances? And it looks like Miss Looney, it looks like this is about the reunification counseling. I see Mr. Zandy. Do we have Heather? Oh, here we go. Okay. So I know this is on for a review. I don't know if this is a matter that needs to be in front of Judge Evans. If it does, I don't know if you want to set it over to the 6th.
I think that makes sense. Mr. Zandy, what do you think?
I don't have any objections, Judge. I don't think it's assigned to anyone or makes any sense if you hear it or Judge Evans or any practical difference. I'm fine if it goes over to the 6th. My client just recently gave birth to a child and only recently got out of the hospital. So there's been some delay in getting a hold of her. We did get the reunification information, so we have that. I emailed or attempted to email the GAL this morning, have not heard back. So I'm not sure. I have not seen any kind of a GAL written findings or anything. Have you, Ms. Hope?
No, you're
so I don't even know, frankly, that June 6th is going to give us really enough time. Right now, we have a 1-page email from Ms. Long on the reunification efforts, but we don't have anything from a GAL and nothing from the child's individual counselor outside of one line in that email from Ms. Long. So if we're going to do it, I just assume be ready so that we're not constantly kicking this can down the line. And I don't know, although I can be optimistic, I'm not sure that June 6th, we're going to be in much different position.
So what are you suggesting, Mr. Zandy? How far out are you thinking?
Honestly, probably the end of June. And I know that Ms. Hope's client wants some kind of resolution before then. Frankly, my client does too. I think everybody wants to somehow move this forward or have some decisions made on it. I just want full information presented so that we can have a meaningful hearing, as opposed to bits and pieces from the reunification counselor, but nothing from the GAL or playing that game, which is always difficult. So I'll leave that to your discretion, Judge. But in all honesty, I think probably late June, maybe the earliest we get all that information.
Ms. Hope?
Well, we've been waiting, I think, something like 1.5 years for the GAL report. So the work was done on that last summer. So it's pretty stale. I imagine what she'd be looking at is the reunification report, which is only one single spaced page, but it answers most of the questions that have been kind of plaguing this case. So I guess I would take 2 tacks. One is if we could set up some interim visitation, because my client's been seeing his daughter, and I don't want that to close down for the month of June until we can get back into court. So
here's Ms. Gravina coming on.
Oh, good. Okay. So we wouldn't object to delaying a return to court as long as he could continue to see his daughter. I think that would be best for her. I don't like those stop and starts. He's had 4 in-office visits, and the reconciliation counselor is recommending that he doesn't need that anymore, that it could be a family kind of family supervised. His father lives in Vancouver and is real familiar with the child and her mother. So if we could set up a couple visits between now and the end of June, that would work for him and I think for the child.
I think my suggestion, Judge, would just be to keep the way it is now to the reunification counseling, and maybe I'm available any day except for June 20th. So maybe June 13th is a sweet spot for that. That will allow my client to give a declaration with input if necessary. Allow Mr. Swingle to do the same thing, and then hopefully have additional input from the child's counselor as well as the GAL at that time. So again, we're all working off the same set of facts.
Ms. Gravina, we are talking about the Marsh Swingle matter and looking to set it over to June 13 to have a little more information, and sounds like maybe to have a report from the guardian item. Is that what I'm hearing from counsel?
Yeah, I think that's appropriate.
So, Ms. Gravina, does that work for you?
Yes, Your Honor.
Okay. All right.
When could we expect that report so that we can review it prior to the hearing date?
I will have that out as soon as I am done on docket here. I just have to go get printer ink. I ordered it and forgot that it was a holiday weekend. So I simply just need to get that over to you today.
Okay. All right. So it sounds appropriate to go ahead and set this over to June 13 at 9 a.m.
Thank
Your
you.
Honor, I'm sorry, just one more thing. The reconciliation counselor indicated that her input isn't needed anymore or supervision. Could we set up those visits at my client's father's home then from now, the next few weeks?
Well, I'd kind of like to be heard on that. And again, I think we're only talking about 2 visits between now and June 13th. And I think Ms. Long is still available for those. So I would just suggest that we keep the status quo with what we have until June 13th when we reconvene.
Yeah, so I'm going to leave it as status quo at the moment. I understand there may be a recommendation, but at this point, until we have Ms. Gravina's report and has some input from her, and to see where things are at. I think the 13th, that's only 2 weeks, so it's not that far. Ms. Bliss is on here. Do we have Adrian Godby?
I don't anticipate him appearing. I think his involvement in this case was the very first temporary order hearing, and then he's gone silent since. I did receive an email from him after receiving the notice of the trial dates being set and today's hearing. He indicated that he was open to discussions, but that was the extent of his correspondence with me.
Okay. All right. So with that, let me mute this connection. It's on for pretrial management hearing, so I don't think there's really anything that we need to discuss. All right.
Nope, I think
Takes care of that matter.
thanks.
Thank you. And Mr. Fuel. All right, let's see, Ann Height. Okay.
Just before we begin, I noticed in the court file a reply declaration filed on behalf of Thomas Peterson. Mr. Fuel, could you indicate to me how that was served upon my office?
Yeah, that was only via email at this point. I know that I need to get a hard copy too. Your Honor, we're going to ask actually if we can kick this over a week. My client would feel more comfortable if Judge Evans was hearing this matter.
And I would absolutely contest that. There's no reason. I prepared for this hearing. I did not receive the reply declaration via email. I had my staff check. I checked. So I only found it this morning, but I got ready to go forward today, regardless, because there's nothing I can do to respond to a reply. Your Honor heard this case back in the fall, so it's appropriate that you hear it again. So anything other than that is sort of just, again, making my client sit through a docket, having me prep for it, and then saying, oh, I'd like to take it over now. So we should go forward.
And it's only been 12 minutes and it is our motion.
Okay. So I think you have a right to set it over, but at the same time, for setting it over without any notice, I am looking at terms if that's going to be granted. So as long as that's understood.
Understood.
All right. So I will grant $500 in terms for the necessity of having prepping for today. Additional attorney's fees can be requested at the time. So I'll set this over to June 6th at 9 a.m.
Thank you, Your Honor.
Very good.
I know Ms. Farr is here, Mr. Anagnoscu. In reviewing the file, I see there were a couple of documents that I needed to follow through on. So while we're here, I was going to appoint Ms. Farr as a guardian ad litem. She had previously been the court visitor, but I was going to change her status, which gives her a bit broader investigation or investigatory authority. So I'm going to sign that. Ms. Wilson had asked for an attorney. She was previously represented by Mr. South. I've been doing what I can to locate other attorneys, and I've found an attorney in Vancouver named Dino Gojak, and I'm going to appoint him as the attorney for Lacey Wilson. I'm going to sign that right now.
And Your Honor, we also need an attorney for Jackson.
All right, do you think we need that even with you serving as a guardian ad litem?
Well, I haven't actually talked with him yet, but that's what I understand the request is. I can interview him first. And
let's find out if he wants one and if you have a recommendation after that.
Okay.
All right. All right, I see Ms. Bodine is here also. So Vance Baldwin is represented by Mr. Anagnoscu, who is also here. With these appointments, it seems to me we need to probably put this case over again to allow contact between the attorneys and Ms. Wilson and also Ms. Farr for you to do additional work.
Your Honor, how do I get a hold of my attorney? Like, how do I get the information for that?
Let me give you a phone number And call him tomorrow. I'm going to send him an email about the appointment today. Okay.
Okay, thank you.
Right. How far out do you feel we should go?
We just have an immediate order, correct?
Yeah, we've had an immediate order for a while. Ms.
Okay.
Bodine, let me ask Ms. Bodine a question. Have you filed for full guardianship yet?
Yes, the court date,
Do you have a court date?
June 15th, yes. I still have to serve because they charge me $100 at the sheriff's office.
Okay. What I was going to do then is extend the emergency minor guardianship to the hearing on the full guardianship. In which we probably don't know exactly when that hearing is going to be. So I indicated it will be determined in the future. But I'm glad that got filed. How far out do you think we should go as far on this case?
Well, I would say a month, but if you want to set this for review on the 15th with the regular petition, that's fine. I don't think that I'll have a report by then.
Okay, I think that makes sense to do that. Lacey, we're getting feedback, I think, from you, so I'm going to mute you just for that reason. All right, thank you. It was. All right, we'll go ahead and set it for June 15th.
Yes, in the interim,
at
I
10:30.
just want to point out to the court that my client is here, Vance Baldwin. How do we go about getting some residential time started? Does he just contact the petitioner, Megan, and we should be able to at least set up some maybe video or phone or even, personal contact if they'll allow it.
So there's a no contact order between Vance and I haven't been notified from the victim advocate when that expires or how to go about dealing with that with the kids. Or else, I wouldn't have a problem with that, but I don't know how to go about that legally at this point.
I was unaware there was a protection order, so that creates a problem.
Right.
Why don't I have the parties look into that, and maybe we can address some sort of contact with the children when we come back on June 15th. It sounds like Ms. Bodine is open to it. We just need to address where we're at on the protection order.
Yeah, and his progress, just make sure he's mentally ready for that. So, yeah.
Okay.
Honor, what about me?
Ms. Wilson, I think I want you to talk to your attorney first, and then we're going to have to address that again on June 15th. Powers is here. Okay. Ms. Powers, did you see the declaration that was filed?
From Bernadette Kaiser, I did.
Okay, good. Ms. Powers, why don't you go ahead and go first, and then I'll let Ms. Bliss respond, and then we'll see where we go.
Thank you, Your Honor. We're here today on the state's motion for order to show cause to vacate part of the final order that was entered by the court on March 1st, 2023. Both parents, Patrick Kaiser and Bernadette Kaiser, were personally served with the order to go to court in our pleadings on May 5th, 2023. Final orders were entered March 1st, 2023. Section 22 of the minor guardianship findings and order state, given the children's extraordinary income, child support is not appropriate in this matter. The kids in this matter have actually been on TANF with the guardians since November 2022 and are still presently receiving TANF benefits. The state was not served or given notice that the final orders would extinguish the state's right to collect child support. The state had been in the process of establishing administrative orders of child support at the time that this final order was entered. We're asking the court to allow the state to intervene in this matter, to also vacate section 22 of the findings and order, and to establish child support orders against both parents. We have sent over a proposed order allowing us to intervene and vacating section 22 and replacing it with the language contained in our order. We basically switched out the sentence to allow the court to enter child support. I don't know if the court wants to address child support today or at a later date. We have proposed child support worksheets and child support orders. But I'd like to know if the court just wants to handle the vacate today, or if you want to do both the vacate and child support today.
The declaration by Ms. Kaiser suggests that I should additionally look at the income of the petitioners. I'll hear from Ms. Bliss, but my initial reaction to that was that might make sense. And so that might put the actual decision on child support out a ways. Ms. Bliss, why don't you respond?
I'll respond briefly just to what Ms. Powers has presented to the court today. As contained in my client's declaration, there's no objection to vacating the final order. I've explained to my clients that when the state is involved and TANF is involved, they simply just don't have a choice. As my client indicated in her declaration, we were unaware that the children were receiving TANF. And I don't believe the state had made an appearance in this action when the final orders were entered, excuse me. So this was just an oversight on our behalf. And we have no objection to the court vacating. As Your Honor indicated, there are some discussions in my client's declaration as to child support and the dollar amount, as well as the medical care and the tax exemption. But I'll hold off on making argument on that pending Your Honor's ruling and a position of Ms. Powers.
All right. So I will grant the motion vacating section 22 and allow the state to intervene. I guess the question then is, do we need additional information before we can go forward with the child support order? According to Ms. Kaiser's declaration, again, it would seem we would. Is that information that you could provide, Ms. Bliss, to the court, what the petitioner's income is?
I
don't have knowledge of that.
I do
Sorry.
have access to the petitioner's employment security data, but I actually don't think that it's proper to include the petitioner's income. I was reviewing RCW 11-130, 230, and 235 about the duties and powers of guardians for minors. And section 1 does indicate that a guardian for a minor has the duty and responsibility of a parent regarding the minor's support, care, education, health, safety, and welfare. But as you read further down both statutes, it talks about things like expend funds of the minor which have been received by the guardian for the minor's current needs for support, care, education, health, safety, and welfare. That's section C of 230. And then in section C of 235, it talks about the minor guardian. If the minor is not subject to conservatorship, then the guardian can commence a proceeding, including an administrative proceeding, to take other appropriate action to compel a person to support the minor, pay child support, or make other payments for the benefit of the minor. My understanding is that the law requires legal parents to provide child support for the parents, but does not require guardians to provide child support for the children. Additionally, RCW 2619-001 also talks about the parent's responsibility to provide child support. In all of the years that our office was doing non-parental custody actions, we never included the non-parental custodian's income in child support. We always only included the parents' incomes. And I believe that that's still appropriate under the minor guardianship statutes.
All right, thank you. Ms. Bliss, any response?
Just briefly, as contained in my client's declaration, RCW 11-130-255 essentially places the duty to, enter support on Your Honor. You have the ability to consider one or both parents. You have the ability to enter an order child support or not. I think the law is in a very gray area right now, given the age of this statute. I don't believe that there's been much case law to suggest one way or the other, but I do believe that Your Honor has an immense amount of discretion when ordering this. As contained in that statute, it's a matter of reasonableness or an amount necessary to support the child. I do think it's appropriate to include the income of the petitioners, as they are the ones that are providing the immediate care and support of these children, not negating the fact that my clients do have an obligation to support their children. But as contained in my client's declaration, she agreed to allowing them to stay with the petitioner. Petitioner made the request to take on this immense responsibility of taking on the care of the 3 children. So I do think that it is important looking to child support actions between 2 parents, or including both the parents' incomes, regardless of who's caring for the children. I think that's synonymous here. The petitioner is caring for the children. They're the legal guardian of these children. Granted, they're not the parents of these children, but they are taking on a legal responsibility for these children. And I do think it's appropriate to include their income.
All right, I'm going to put this over 2 weeks. And let me get the date on that. That would be June 13th. Ms. Powers, I would like you to file the income of the guardians with the court. That doesn't mean I'm going to consider it, but I do want that information. I do want to look at the interplay of these statutes before we come back. And then we'll make a decision 2 weeks from now. Okay.
Okay, thank you. So
All right.
is the court signing my order vacating today?
I do have it in front of me. Let me take a look here.
Okay, my one question on there is I had just copied the language from section 22, which does also include information about the tax issues and health insurance. If the court wants to cross that out and just leave it that child support shall be ordered, health insurance and tax issues could be addressed in the child support order. They don't have to be addressed in section 22.
I think I'll leave it as is. Ms. Bliss has raised the tax exemption issue. And also there was indication where the parents wanted to cover the children on their medical. So I think all of that is, I guess it does say parents must continue to cover child and their health insurance. So I'm going to leave it as is.
Okay, thank you.
And with that, I propose, I would suggest maybe that I revise the final minor guardianship order to reflect this change. I think it's probably appropriate just because, I mean, I drafted the initial, so I don't have any objection, including Ms. Powers' language. I think that just might make the record a little cleaner if we had an amended final order.
And if you want to do an amended final order, that's fine. We can take care of that also on June 13th.
The 13th. Okay, very good. Thank you, Judge.
Ms. Farr filed a supplemental report. Did have the parties been able to review that?
Yes.
Yes, Your Honor.
Your Honor, I haven't had an opportunity to get my notice of appearance in, but I'll be appearing on behalf of Brian Fletcher and Tracy Hedrick.
All right, thank you. You probably haven't seen Ms. Farr's supplemental report.
I only had an opportunity to glance at it this morning.
Okay.
That it was in Odyssey.
All right, I guess just to summarize where I think we're at is initially the Fletchers requested guardianship of Serenity Aldrich. And then the Scott and Jessica Aldrich also requested guardianship. Both parents filed consents to Scott and Jessica Aldrich under, let me just be sure. Under RCW 11-130-185 indicates the court may appoint a guardian for a minor who does not have a guardian if the court finds the appointment is in the minor's best interest and each parent of the minor being fully informed of the nature and consequences of the guardianship consents. Based on that, I granted the full guardianship. Soon after that, the Fletchers moved for reconsideration. I denied that motion based on the consents that I received. And then I received Ms. Farr's current report indicating that, well, let me also say that I got an ex parte motion to appoint an attorney for Miles Radcliffe last week. That appeared to be generated by the Fletchers. I denied that at the time because there was no indication of what Mr. Fletcher's income was, and I needed that before I could determine if he was entitled to counsel. After that, however, I got Ms. Farr's report showing that Mr. Radcliffe is not on the birth certificate, and apparently there's been no paternity action. And the suggestion is that I should dismiss Mr. Radcliffe from this proceeding because there's no legal, there's nothing legally that indicates that he's the father at this point. So that's where I see where we're at. Why don't I just kind of go around, Ms. Farr, anything you'd like to add to that?
The only other thing is that at this point, I believe that Mr. Fletcher is now an interested party and not an actual party to the action. I think that changes some of the dynamics. I did file a supplemental report. Lillian has made some progress. She's participating in parenting Serenity while she's doing her Saturday visits, and I was recommending that her visits are extended. However, she still hasn't provided me the ROIs or done the drug testing or enrolled in the mental health outpatient. And I believe she, I suggest that she does those things right away. I've talked with her about those things too. I know that she's, trying to, she just started a job and she's trying to establish residency, and she's, making all these strides, and that's fantastic. But there are some of these things that are lingering that still have to be addressed as well.
All right, thank you. Mr. Anagnostou?
Yes, as indicated, I'm representing Brian Fletcher and Miss the petitioners in the guardianship action. There's a confusion with regards to these two cases, because you have the 078 file, which is my understanding is an emergency guardianship, and my client's petition for guardianship. They've basically had custody of the children. They resided a lot of the time with my clients, and in this process, they were placed with the other petitioning parties based on consents of the parents, one being the presumed father or alleged father, and he is now indicating, he wants the children's serenity to be placed with my clients. And I understand there's a issue now being on the birth certificate, but that can be resolved by genetic testing. But he's been held out and is the father of Serenity, and it's a new development that they're potentially claiming that because of that lack of his name on a birth certificate, he doesn't have legal standing, which up until this point, he's been held out and been the father of Serenity.
Ms. Aldrich, Lillian Aldrich, anything you'd like to add?
Just that, of course, I would like visitation to be extended as well. I want to see my daughter as much as possible, but that I believe my daughter is good where she's at. She's healthy, happy, safe, secure, and she's with a family that she's been with for her whole life. That I don't want anything to change right now besides the visitation, if possible. I think she's good where she's at, and I don't think that the other parties need to have any part of it. And that Miles should definitely establish paternity before anything gets further with his name.
All right. Either of the Aldriches, Scott or Jessica, anything you'd like to add?
Serenity is doing really well, adjusting, and just a happy little girl.
What is the current visitation now, Ms. Aldrich, Lillian Aldrich?
It's every Saturday.
From when to when?
10 to 2.
Okay.
And I am enrolled in mental health at Columbia Wellness. It's just not necessarily an outpatient program. It's just I just have a therapist. Yeah, and I was hoping maybe that I could possibly be like, because both the parents work, I was hoping to maybe be like the child care for my baby when they go to work or something like that, just so I could maybe see her more. Just that way the baby doesn't have to go to like other people while they're at work. Because I know that there are sacrifices being made, and people and they're tending to my child before their jobs when it comes to some days and stuff like that. And I just want to be able to help with that as much as I can.
And these are being supervised, the visits are being supervised by Ms. Aldrich, is that right? Or
Sorry, Scott and I.
Okay.
Your Honor, also the current current visitation says that the supervision is to take place in the Aldrich's home, and they're asking if that could be changed so that it's just under their supervision, so that they're allowed to have visits outside of their home as long as they're supervising.
All right, I want to make sure with both Scott and Jessica Aldrich that what I'm going to propose, it works with you. But I would propose extending Saturdays to 6 p.m. rather than 2 p.m. and maybe adding a Wednesday afternoon visit, like 5 or 6 to 8, something like that.
That would be fine.
And also, I would add that it can be outside of your home as long as one of you is with the child during that time.
That sounds good.
Those changes sound okay?
Yes.
All right. So we'll go 10 to 6 on Saturday. I'll say Wednesday 5 to 7, and then outside home.
Your Honor, I do have a job and the schedule is not set in stone yet. Is there a way that this could possibly be adjusted according to that schedule before the next court date? If it doesn't, it's because I need to make sure I focus on employment and things like that as well as my daughter.
Well, it sounds like Saturday would be okay. Can you communicate with the Aldriches and let them know? I guess what I'd like is a weekday visit for 2 hours. And if that needs to adjust with your schedule, can the parties work on that?
Yes.
Okay. All right.
So she may end up having to work on Saturdays too, is what she's saying. So what will we do in that instance?
Well, I guess it depends on what your schedule is. The easy thing would be to move it to Sunday. If that doesn't work, then maybe that Saturday is lost and you're not able to really get that back. I think the framework here is a Saturday visit and a weekday visit.
Okay, so do I have the authorization to move that then, or do I need to get authorization from somebody if that needs to happen?
I would say you have authorization if any one of the parties is working on Saturday, then try to work out another date.
Okay.
Thank you.
Okay. All right. I need to make some other decisions here. So right now it appears that Mr. Radcliffe does not have a legal right. And because of that, I think it's appropriate that he be dismissed from the actions. Also, Ms. Farr has indicated that the action ending in 00078 be dismissed. It looks like we filed a full guardianship in both the 133 and the 078 case. And so I'm going to dismiss the 078 case. And out of the 133 case, I'm going to dismiss Miles Radcliffe. Now, that's going to be without prejudice so that if he does establish paternity, he can come back, ask to intervene and be involved again in the case.
So Your Honor, if I could raise an objection,
Sure.
There's been no notice of a motion to dismiss, no opportunity for me to respond to a motion for dismiss. And so I would ask Your Honor not to dismiss it until there was a motion with an opportunity to respond.
Are you saying dismiss Mr. Radcliffe or dismiss the 078 case?
Dismiss the 078 case.
Okay. So you're not objecting to dismissing Mr. Radcliffe?
Well, I am. In this sense, it's been my experience in these actions that the court gives an opportunity in these circumstances for genetic testing to occur.
He's giving him that opportunity. He just wants to do it before he participates further.
I'm sorry, I didn't catch that.
You want to?
It sounds like he's giving him the opportunity. It's just he's waiting until it's proven that he's the father.
All right. I out of
Actually,
an abundance.
Yeah, Your Honor, if I may, in my
ahead.
experience, procedurally, the correct way would be for Mr. Radcliffe to file a paternity action outside of the guardianship proceedings to establish paternity. I've had a few cases that have happened that way. And I guess I'm not understanding why Mr. Anagnostou would be objecting because he doesn't represent Mr. Radcliffe.
Sure, I understand. All right.
Well, I'm objecting because that affects my client's case, the 078 case.
All right, I'm going to dismiss Mr. Radcliffe as a party in both the 133 and the 078 case. I'm going to put the 078 case over 1 month. I guess that's to June 27th. For the purpose of addressing whether that case should be dismissed. And Mr. Anagnosti then and his client can prepare their argument on that issue.
So does a motion need to be filed for that, or we're just going to set it over and have an argument?
I'm going to say today's discussion is the motion, and we'll have that argument then. Meanwhile, the full guardianship in favor of Scott and Jessica Aldrich remains in effect.
Thank you.
Okay, with the increased visitation to Lillian.
Thank you.
Okay. All right, thank you, everyone. So let me ask you, Ms. Martin, what's your position on the emergency minor guardianship petition?
I do not feel it was fair, Your Honor.
Okay.
Oh, and if I may, I do not have an attorney at this moment, so if I may I have a public defender, please?
Are you currently working?
I am currently in the process of looking for work.
Okay.
At this moment, I'm receiving public assistance from the state to support my child at this moment.
And what kind of assistance are you receiving?
Food stamps and TANF.
Okay. All right, I'm going to appoint an attorney named Tom Lee to represent you.
Thank you, Your Honor.
And he's in Longview. You can look him up, but I'll give him information so he should be able to contact you.
Thank you. May I have his phone number, please?
I don't have that with me right off. I'm sorry, I don't. I will have him reach out to you, okay?
And the attorney's name again, sir?
Tom Lee, L-E-E. Ms. Leeper, it looks like we need to serve both parents, or do you know if that had been done?
Catherine Martin has been served, and I couldn't get an answer whether or not Chase Shop, my son, was to be served because he signed the consent form for me to have emergency guardianship.
So we still need service. Now, I think there's a document in the court forms under Washington court forms where he can sign an acceptance of service.
Okay.
So either he needs to be served or sign the acceptance, even though he's done the consent. Okay.
Okay.
Good. And then whoever served Miss Martin will need to file a declaration with the court as to the date and time of that service. Okay. I'm going to do two additional things. I'm going to appoint a guardian ad litem who will investigate this case and help court understand the issues. So that person is going to be Tina Day.
Thank you.
All right. I would typically put this out a month, and I would extend the immediate emergency minor guardianship orders. So that would leave Ms. Leeper as the guardian during that time.
May I request visitation with my child, Your Honor?
Okay, I was wondering if that issue would come up. So let me ask Ms. Leeper what your position is on that.
Your Honor, I feel like visitation would be okay. I would request that there would be somebody with Catherine and Kathleen, and same with Chase Shop. I would request a supervised visit with both of them, because I feel like both with their different situations that they need to work on, I want to keep my granddaughter safe. So a supervised visit, I think would be wonderful.
Is there somebody you would recommend for that?
If Catherine has somebody that she feels would, help her with Kathleen, I myself would, allow Chase to see Kathleen supervised by me. And if Catherine wants to meet on mutual grounds, I'd be willing to, bring Catherine, their names are so close together, Kathleen for visits as well.
Ms. Martin, is there anybody that you would recommend that could supervise visits?
If I may recommend my mother, Tamara Coyne Hettinger.
Any objection to that, Ms. Leeper?
No.
Okay. If we did a visit, let's see, Kathleen is 2 right now.
Mm-hmm.
So for the next month, let's do a visit from Saturday from 10 to 2.
May I request that it be here in Longview, Your Honor?
Where do you live, Ms. Leeper?
Tacoma. So I would request, Your Honor, that they would meet me halfway.
I think we're going to have to pick a halfway spot, and I'm sorry that it does make it somewhat inconvenient. And just timing wise, the visit with the mother needs to start at 10 and then it will end at 2.
Yes, Your Honor.
So travel time will not be included in that visitation time. Okay.
Okay.
So Ms. Leeper, you may have to start around 9:15 to get up there on time.
Right. With traffic. Yes, Your Honor.
Okay. So we'll leave that Saturday 10 to 2. We'll do that for the next month.
Okay.
Thank you, Your Honor.
And then we'll get together again on June 27th.
Thank you, Your Honor.
We'll be Zoom. Okay, I'll do these orders. Ms. Day will begin to get involved, and we'll see where we're at on June 27th. Okay.
Thank you, Your Honor.
All right.
Thank you.
Thank you, Ms. Leeper. Thank you, Ms. Martin. I'm glad you're here. Last time we were here, I indicated that today we were going to have a full hearing on Lance Lewis as to whether the court should appoint Gail Levitt and Roy Levitt as the emergency minor guardians. And are the parties ready to proceed on that?
Yes. Can you hear me?
Yes, I can. Thank you.
Yes, I am.
Okay, good. All right, we will start with the petitioner, Gail Levitt. Is that right?
Yep.
All right. So when we do a hearing, then I place the parties under oath. So I'm going to place you under oath and then have you testify about why you feel the guardianship is necessary. And then I'm going to go to Ms. Day and ask her what she has, what her conclusions are. And then I believe I'm going to go to Mr. Anagnostou, and he will.
My client, yeah.
Okay, and let me just check something here. All right, tell the court in your own words why you feel a minor guardianship is necessary for Lance Lewis.
Well, first off, his parents are both homeless. They're living in a shed behind my ex-husband's house. Lance was not taken care of well. I've had him for 4 months. I've got him in we care daycare. He gets kicked out of school, got kicked out twice last week. He's got behavioral issues from the way he was raised. I went to this Kelso School District and we had him assessed at Wallace. So we'll see how that goes. I've got him signed up for Head Start. He's doing, when I first got him, Your Honor, he would spit in your face, kick you, hit you. We have made great bounds, but we're not there yet. I've got an appointment on the 9th for him to have some counseling at Core Hill. On the 6th, we're getting his front teeth capped because they were not taken care of. He's way better off with me. I'm not saying that, someday maybe if like he says, my parents need to get their stuff together. And he calls my house home and he's adjusted. It's funny how kids adapt. And he's home at my house. They came and brought his clothes yesterday, finally, after 4 months. I let him go with them to the park for a couple hours. And that he just said, okay, bye, so he has adapted quite well. And until they get their lives together, there's no need to put this little boy through that.
How old is he right now?
4.
Okay. So he's not in kindergarten yet?
No, we're trying for pre-K, but we can't figure out after the assessment to be in a behavioral situation or not. So we're working on that right now, but we have signed up for Head Start and we've been to Wallace School where they have the behavioral classes.
What is your thought on visitation with the parents?
As long as it's not negatively affecting him. Well, like yesterday, they were going to come. They said they'd be there in 20 minutes to a half hour, and an hour and a half later, they arrived. Well, that just made him kind of crazy. You know, that you can't do that. I said I wasn't home by 3. He was home by 3:15. So that wasn't too bad, but they have to be consistent, you know, and they have to say, if I'm going to come visit my son, you're going to do it on my time, first off, and you're going to be on time. You can't, that inconsistency, that's not fair for his little being.
Okay. How long has he been living with you now?
I think a little over 4 months.
Okay.
So in 70 days, Your Honor, his mother called him 4 times in 70 days.
And you indicated something with his teeth. What was the condition of his teeth when he came?
He's got his 2 front teeth here are crumbling. So we have an appointment on the 6th to get those fixed.
All right. What kind of insurance does he have?
It's through the Apple.
Okay, through the state. Mr. Lewis, I'm going to mute you because we're getting some feedback. What's his living arrangement at your house? Does he have his own room or?
At his own room, yes.
Okay.
And a swimming pool and a bike and lots of books, and he's very well taken care of at my house.
All right. Anything else you want to add at this point?
Not really. I just, you know, we've got to take care of this boy and get him on the right track.
Okay, so you'll have a chance to respond to anything Mr. Anagnostou or Mr. Lewis or Ms. Barnes says. And it's important that you just listen while they're talking, and then I'll give you a chance to respond, okay? All right, thanks. Let's next go to Ms. Day. Ms. Day, I'm gonna go a little bit out of order here. Mr. Anagnostou, did you have any questions for Ms. Levitt that you wanted to ask?
Yes, Your Honor. I was going to ask.
I apologize for not giving you that opportunity. So go ahead.
Right. You want me to ask the questions now?
Yeah, let's do that now.
So my client, Monique Barnes, is she visiting with her son?
She's called him 4 times in 70 days.
Okay.
I called her on Mother's Day to say that he had a gift for her. So she saw him 15 minutes on Mother's Day. And yesterday she saw him for like 2.5 hours. That's it in 70 days.
So 2.5 hours yesterday, and you let her take him to the park, or
her and his father.
Okay.
Because they're evidently back together. I don't know.
All right. Yeah, that was my question, Your Honor.
Would you like to indicate your report in this case?
Yes, Your Honor. So I was appointed as a court visitor in March, and I provided my report at the end of April. In that investigation, I was able to meet with Ms. Levitt. I was able to meet Lance and visit him at home with Grandma. I have not had any contact with Gary Lewis, the father. He had signed a consent, and I had no way of reaching him. At the time I was appointed, he was incarcerated. I see now that he's out, but I haven't had any contact with him. With Mother, I have had very limited contact. I was able to reach her a couple of times, always with the promise that she was going to fill out the paperwork and call me back and meet with me, and then never responded. She would show up in court and say that she wasn't able to meet with me. You would set it over, and we would kind of do the same thing again. So my contact with her has been limited. I was able to talk with Jennifer Olson, who was the CPS investigator. She expressed significant concerns about the neglect that Lance and the other children were experiencing that Mother has. Lance is the only one involved in this guardianship. She expressed concerns for medical neglect, physical neglect, and ongoing substance abuse for both the parents. She was having extreme difficulty even tracking down Mom with the other kids, but she was able to do that. I understand now that Mother has obtained some sort of temporary housing. They've closed the case for the other 3 kids, and Lance is closed because he's in the guardianship with Grandma. So my recommendation is that he is in need of a guardianship. He has suffered extensive dental and medical neglect and physical neglect. He is in need of a safe and stable home. He's in need of counseling and the ability to move forward academically, so he'll be ready for kindergarten next year.
All right, thank you. Mr. Anagnosto, any questions of Ms. Day?
No, Your Honor.
All right, thank you. Mr. Lewis, I think you've filed a consent in this case, allowing Ms. Levitt to be the guardian, at least the emergency guardian. Is that still your position that you consent to that?
Yes, Your Honor. But I just want to establish some visitations, maybe like, a couple days a week. I didn't want to overnight visit with my son. So I just wanted to try to establish some of those.
All right, I think Monique Barnes is back with us, so I'm going to turn it over to Mr. Anagnosto, and Ms. Barnes, you can go ahead and unmute yourself.
And you've heard the testimony of the petitioner, Gail Levitt, right?
What was that? You broke up a little bit.
You heard the testimony of Miss Levitt, correct?
Yeah, yes, I did.
What do you want to happen with regards to your son?
Well, I don't have my own stable place right now to live. So, I mean, I'm not asking for him back right now or anything. Once I do establish that and have a job and have everything in order, we'll figure that out from there. But just for now, I would like to be able to see him and know if I am allowed to call him every day or what stipulations I have and what I should do. I don't know if I'm supposed to ask or this or that. And it's kind of screwed me up and all that. So knowing what to do would help.
You had a visitation this last weekend, correct?
Yes.
There's been a complaint that you go a long period of time with no contact with your son.
That's not true. I have a lot of stuff on Zoom that I prove that I call him all the time. My mom calls him a lot. Buddy calls him, and I have called way more than that. And I can submit that to the courts if I need to. And I was only told I could call twice a week, so I wasn't sure if I was supposed to call more than that or not. I'm more than willing to call every day.
All right, and then you want some regular contact with your son.
Yes, please.
What is your suggestion?
Whatever she's comfortable with. If that's, going over there for a little while, or, me and dad being together and taking him to the park, or doing me and him separately, whatever she thinks is good and she's comfortable with.
All right. She indicated that you're living in a shed behind your dad's house. What is your living condition?
That's not true. I've been staying with my mom.
Okay, and your lives in Kelso, correct?
Yes.
But go ahead. Ultimately, what are you going to do with regards to your living situation?
I have an interview coming up, so I'm hoping that I get the job. And as soon as I get that, I have a good credit score. I could go buy a house if I want. So, plan on either renting or buying, and then keeping the job.
Okay. And until you have your housing situated, you don't have a problem with your son staying with the Levitts. You just want regular visitation and phone contact and various other things. Is that correct?
Yes, yes. Definitely. I'm grateful for her helping out and giving him a stable place while I don't have one.
There's allegations by the petitioners with regards to lack of medical care and dental care and mental health. What's your response to those allegations?
What are they? Because I don't understand, because I never got in trouble with CPS. I've had a ton of cases. All my kids have had all their medical stuff taken care of. He had glasses before he went with her. He had his teeth taken care of. He'd been to the dentist, everything. I don't understand. He has 2 caps he needed done. And I already knew that before she had a visitation and served me with these papers. So I'm not really sure what that is.
All right.
Because even when Lance was born, there was an open CPS case because he was so small, and even the dietitian and everything didn't find anything wrong with him. We did start giving him the Pediasure. We made sure that he ate first and then got the Pediasure, but he hasn't, he's just a slow grower, but I don't know how much. He didn't seem like he'd grown too much since I'd seen him last.
Well, in any event, at this particular time, you're not opposed to the guardianship, but once you solve the housing, you want you want him returned to your care.
Yes, sir.
I don't think I have any other questions, Your Honor.
All right, thank you. Ms. Levitt, any response to any of that?
Oh, I could respond a lot. I think I'll just leave it the way it is. I told my side of the story and I was truthful. That's what I'm going to say.
Okay. Ms. Barnes, I want to ask you a question. In terms of visitation, can you and Mr. Lewis do that together, or do you think I should establish separate times for the two of you?
We can do it together.
Okay. All right, thank you, everyone. Is there any closing that you'd like to make, Mr. Anagnosti?
No, Your Honor.
All right. So let me go over what we're here about today. So the request is for an emergency minor guardianship order. That order initially lasts for 60 days, and it can be extended one time for another 60 days. If Ms. Levitt, you feel a guardianship should go on longer than 120 days, then you'd have to file for what's called a full guardianship, and that would be another petition. So you may want to keep that in mind. What we have is Mr. Lewis indicating that he consents to Ms. Levitt being an emergency minor guardian. And Ms. Barnes has essentially indicated the same thing, that she's not in a position to take care of Lance at this point. She appreciates what Ms. Levitt is doing, but she both would like visitation and would not like this to be permanent because she thinks her living arrangement is going to change in the future. Let me go over what the standard is. So when a petition is filed, then the court may appoint an emergency guardian for the minor if the court finds subpart A, appointment of the emergency guardian is likely to prevent substantial harm to the minor's health, safety, or welfare. And B, no other person appears to have authority, ability, and willingness to act to prevent substantial harm to the minor's health, safety, or welfare. All of that has to be proved by clear and convincing evidence. So first of all, with the consent, I think that we really don't have to discuss the issues with the father. The general issues that have been testified to. So apparently, maybe around the time the petition was filed, the parents were homeless. I understand the mother's moved in with her mother now. That Lance has had some behavioral issues, that his front teeth needed to be capped. And since Ms. Levitt has had Lance, there's apparently been limited actual visits with him by the mother. She's indicated that she's talked to him on Zoom numerous times. Ms. Levitt has enrolled him in preschool, has taken care of his insurance, has provided his own room. And there's no testimony that the mothers would be able to provide those things. So even though both parents certainly would have the authority, and the mother is here indicating a willingness, what I'm going to find by clear and convincing evidence is at this time, she doesn't have the ability to prevent substantial harm to the minor's health, safety, or welfare. And based on that, I'm going to grant the emergency minor guardianship petition. Let me just throw out something initially, and that would be a visit every Saturday from 10 to 4, if that would work for the parties. And I think also a Wednesday or some weekday visit, if Wednesday works, great, from something like 5 to 7. Would that work? Okay. And then Ms. Barnes has indicated she's done some Zooming or telephone calling with Lance. I would like to see that continue. If it's easier for Ms. Levitt, we can adopt a schedule, or she can just do it when she wants. Okay, so I'm going to indicate unlimited telephone calls or Zoom, so that they can just remain in touch. Okay.
Okay.
And I'm, I don't know that a full guardianship is going to be granted down the road. So I think it's really important at this time that there is contact maintained with Lance. Ms. Day, it sounds like you want to say something.
No, Your Honor, I don't object. I think visitation is important, even if a full guardianship is granted later. It's always good and healthy for a child to have contact with their parent. 10 to 4 might be difficult if housing is a challenge. So I don't want either of the parents to be faulted if they don't use the whole time. I just would agree with Ms. Levitt. It needs to be consistent. So if they can't use all 6 hours and they only can do 2 hours on the weekend, then it should be 2 hours consistently. I don't want them to be faulted for that because housing makes that difficult. Right now it's summer, things are easy, but you know, outside visits are good, but it may not be that way. So that would be the thing that I would add. And then I think that was the only thing I was going to add as far as visits.
All right, thank you. Mr. Anagnostou, anything you want to add as far as the visits?
Basically just the same comment that client would like it to be flexible so that she could contact Ms. Levitt and work out visitation. We can set these as kind of guidelines, but then if the parties discuss and agree to other days and times, that would be okay.
Ms. Levitt, what do you think about having some flexibility in the?
Oh, absolutely.
Okay.
Then, Your Honor, I'm going to need to get off so I can get to my next appointment, but I want to let you know I'll be submitting my declaration for fees so that could be included in the temporary order.
Okay, that'll be great.
Thank you. Thank you, everyone.
And I will put in the bench order the Saturday and Wednesday or when otherwise agreed.
Very good.
Okay.
Thank you, Your Honor.
All right, I appreciate everyone's flexibility. I think at least the emergency minor guardianship really fits the situation where both parents need a little bit of space in order to get things in order. And hopefully at the end of 60 or 120 days, there can be a transition back to
sure.
with the parents. And so that's what we'll be looking for. Ms. Levitt, you're certainly free to file for a full guardianship, and maybe that would be a good idea just in case there needs to be more time. But for right now, I think this is the right decision, and I appreciate everybody's cooperation.
Thank you.
Thank you.
So when do we come back to court?
Thank you.
I should probably check in to see how the visitation's going. So would June 27th be okay? That'd be a month from now.
That's fine.
So
Mondays and Fridays work best for Ms. Levitt because she has those days off. So
well, and these are only heard on Tuesday and Thursday, and actually this case would be heard on a Tuesday. So I'm gonna have it on June 27th.
Okay.
And that's
okay.
And that's a review of basically how the visitation is going.
Yeah, just to review the visitation, the 60 days, it'll be right in the middle of that 60-day period.
Right.
We'll probably set another review just before the 60 days expires to determine if we need to extend it.
Right.
Okay. All right. Any questions, Ms. Levitt?
Nope.
Mr. Lewis?
nope, everything's. I'm happy that my mom can take my son right now while I can't. So.
Okay. Ms. Barnes, any questions?
Nope, that pretty much sums it up.
All right. And Mr. Anagnostou?
No, I'm
okay.
fine. Thank you.
Thank you, everyone.